we'll get through this quickly for you and provide you with some information that will be helpful as we get ready to go through the summer months. And as always, if you have any questions about any of these issues, please feel free to give me a call, email me. You can use my cell phone, which is, I believe it's on my website at the firm. Just anything you need to do to get in touch, anything I can do to help. So what we wanted to do is talk a little bit about some cases that we've had where we've seen or that we're aware of from other jurisdictions or even other entities within the state that their officers are having some issues with, and so that we can prevent them rather than have to deal with them going forward. So with that, we've seen a couple of cases in the last year that have focused in on the failure to identify statute, and which was interestingly just amended this legislative session, and we'll talk about that. It broadens it a little bit, but not as much maybe as we would like. It's important to know that, and I think most police officers are pretty aware of the statute, which is found at Utah Code Annotated 77-7-15. And it allows police officers to stop and request information from a person where certain qualifying facts exist. Officers like to use this to get information so that they can run searches and maybe see if there are warrants or other things. But sometimes it can get us into trouble. And I know of at least two cases, one which I've handled in the last year, where there have been some issues, at least led to litigation, some of it ending successfully in favor of the officers, but requiring them to go through the litigation process, which is never a great circumstance. And they seem to be brought by a certain firm who's looking for those types of actions. So I think it's a good idea to be upfront and aware about what those are. So 77-7-15 requires that in order for an officer to demand this information, that the officer be, or that the person be in a public place. And public place can be a tricky concept for officers sometimes because it's very different than where an officer is entitled to go, for example, in terms of curtilage for a home, or to go onto a porch and knock at a door, those kinds of things. To satisfy the failure to identify statute, it has to be a place that is open to the public. So being on a person's property does not satisfy that. That is private property. Even though an officer can go there and knock on a door because it's open in that sense to the public, it's not considered a public place for purposes of 77-7-15. So a public place would be something that is completely open to the public where anyone can be or is invited to be. An example, of course, would be a park, a sidewalk, and there was a case that that one of our cities had where it was open on an open sidewalk where the court ruled that was a public place. Then it gets a little bit trickier as you start going into, well, what about a store? That's private property, right? But I think there's a fairly good argument that that would be a public place because it is open to the public at large. The store wants people to come in. Now, if the store asks someone to leave, that would be another question because that would be trespassing. But again, there are different sorts of definitions that apply to different areas of law. And I think it would be safe to assume that a public place would be a store, although that possibly could be something someone could raise. So it has to be in a public place, and then also, yeah, and then the officer must have reasonable suspicion to believe that the person has either committed a crime or is in the process of committing a crime. So it's really important that if it's just a witness, someone who maybe witnessed a crime, they are not required to give their identification. And we've dealt with that in the past in terms of when we've talked about officer-involved critical incidents, where we're not allowed to detain the people against their consent, people who are merely witnesses to a crime. So it's important that in police reports, when officers are citing someone for the violation of the statute, that they include facts that establish the person is indeed in a public place and that they have reasonable suspicion to believe that a crime has either just been committed or is in the process of being committed. So the information that they're entitled to get is the person's name. That's the first thing that they can request. So name is one, and that has always been authorized. Then they're also entitled to obtain the person's address and an explanation of the person's actions. So if the person won't provide any of that information, then they can add the first part of the statute, the public place and reasonable suspicion, they can be cited for failing to identify themselves. The legislature this year also added to that, and we had a case where the officers explained why it was important to get a date of birth, and the statute didn't provide for it at that time, but it was really important because you'll get how many John Does or Jane Smiths out there, and we need some type of narrowing information to help the officers make sure that they can more accurately identify who this person is. So date of birth now is required. It is a Class B misdemeanor for someone to not provide that information, and the statute where that is found is Utah Code Annotated Section 76-8-301.5. So that should give you the information for those types of claims. The next one I want to move on to is warrants. It's really important to remember that while warrants are considered per se, they are considered to give the officer authority to go into a place or arrest. They are not carte blanche authority, which means circumstances can change. And if the information changes that the officers become aware of, they need to reassess things. And that can be really difficult, particularly when you're dealing with high stress, dangerous encounters, such as going in on a SWAT operation. It's not meant to say that the officers have to question everything about that in those moments. But where information does become available to them, they need then to possibly pause and reassess. And that is one of the things I think that's really helpful that we're trying to help our officers understand, is that they do need to continually reassess the basis and scope. And what that means is that the officers really should be involved in not just a cursory review of the warrant ahead of time, but really sit down and thoroughly read it, and have, when you have this team execution, have the responsible officer, the case agent, whoever that may be, really sit down and explain what it entails and the reasons for it. So then the officers have a little bit better basis for understanding why they're there and the scope of it. And so we're trying to get the officers also to read through those warrants ahead of time so that they will be personally aware and have an opportunity to ask some of those questions. And it's important to remember when safety always comes first, of course. So we don't want the officers to, in the middle of something that's very dangerous, hit the pause button or stop and say, I have to assess this. Make sure that the safety component has been satisfied. But when that is the case, we need to allow our officers the confidence to pause that button for a minute and reassess where necessary. And the supervisors need to, or the case agents or the people, who are in charge on the scene, not to get offended by that, but take it as an opportunity to, when the safety concerns have been satisfied, to make sure that everything is in accordance with the warrant and with the judge's basis for issuing that. The next one we want to talk about is traffic stops. Those are things we do all the time, every day. It's really important, and we hammer this in all the time, for officers to document what they're doing. But here in these traffic stops where they are engaging in these consensual, fact-developing communications, that they also include the time. As you've read some of the case law updates that we've sent out over the last year, there are quite a few that have addressed these extension of traffic stops. And when we look at the reasons that the courts give for either saying that the officer didn't improperly extend the stop or did improperly extend the stop, they are looking at the time frame. So what the officers want to do is note the time that they stop the car, note the time that they're doing, running the check, when that's finished, when they approach the car and give the papers back to the person. We had another case several years ago where we had officers do a really nice job in this circumstance. And what they were doing is they didn't have a reasonable basis to detain the person beyond the traffic stop, but they felt there was something suspicious. And they wanted to continue having a dialogue to try to develop their suspicions to turn it into a reasonable suspicion and possibly probable cause for arrest. So what they did is they engaged in the conversation and were very friendly. But it was critical to our motion to dismiss, and a basis for the judge's reason for granting our motion to dismiss, is that the officer returns the person's license and registration. If the officer keeps those in the officer's hand or car or does not return them to the person, the courts have determined that a reasonable person would not feel free to leave because they need that information to continue driving, right? So it's critical for the officers to give that back. What our officers did in that instance is they gave the papers back, and then another thing that they did very well and that was really important, and some officers haven't, where the courts have ruled that the reasonable person didn't feel free to leave, is they didn't tell them. When a police officer pulls behind my car and the lights go on, I know I'm not free to leave. And I think most of the public feels that way. Of course, there are always some that don't, right? But those lights mean you pull over and you need to answer my questions and do what I need to for the scope of the stop. So it's important for the officer to let the person also know that they are free to leave. But what our officers did in their circumstance is then they asked if they had a few more questions, or after saying they were free to leave, just said, I noticed that you have this nice purse in your car. That's one of my favorites. Showing some interest as opposed to just doing, starting the conversation without letting them say they were free to leave. Making friends. I always tell people when I'm in depositions, sometimes they get frustrated because I tend generally to be very friendly with our plaintiffs in their depositions, and there's a method to that madness. It's that when you have a good relationship with someone, they are much more likely to give you information than if you are stern or cross or they feel threatened. And so I always tell the lawyers that I mentor with, you catch more flies with honey than with vinegar. And those can be helpful things. So it's okay for the officers then to continue on this line and of questioning, but make sure always that they ensure that the what they're doing is not extending the stop. So if it's not consensual, if the person says it's not consensual, then they need to make sure that they go. It's also okay, we've had some cases that came out this last year where officers did engage in small talk while they were waiting for information from dispatch to be returned. And the courts, some of them went in favor of the officers and some of them did not. Some of them went against the officers, and the basis for that was that the officer had concluded the purpose of the stop. That was stopping, getting the license, registration, checking for warrant information, checking for any what the driver's history is. Those are all permissible things to do. But once that information comes back, the officer cannot continue just by engaging in small talk to, say, for example, to allow a canine officer time to arrive and or allow the canine to sniff around the car. Now, if that happens while that information is being run by dispatch and it hasn't come back yet, then that has been okay. But it's important to remember that once that happens, that the officer release the purpose or the person as soon as the purpose of the stop has been accomplished, and that means running those checks. And as always, to record on a dash camera or a body camera or in a report the times and the fact that those things happened. Fortunately for us, in the case that we had and that we were able to get dismissed right out of the chute, the officers did put in there that we returned the papers and told them they were free to leave. And that was really important to the judge. So they can use those words if they don't have those recordings, which are even better, and show it as opposed to just stating it. That's always helpful. The next one I want to talk about is implicit bias. This is a big one that's going on now. You know, it's interesting as I have been raised by my parents and raised my own children, how we all think and hope that we don't have certain biases, but we really do. It's impossible for us not to have biases, and we find that with jurors as well. We all have biases and I'm not saying that we intend to treat people differently, but our experiences in life shape us, and we don't all have the same experiences, and we have different perspectives. So it's really important to remember that we all have our own biases, and just acknowledging that fact really helps when we are looking at how to prevent issues where people claim we had biases, whether that's for race, religion, gender, anything that relates to that. So being aware that we have that and acknowledging that that includes each one of us, me, you, every one of our officers are going to come to a situation with a certain perspective. I think one of the things that can help us in these ways is to have policies and trainings that address these implicit biases. A simple written policy can do wonders in a case to show that we have, number one, that policy, and then the training, that we have a practice of training it so we can defeat these claims, that we don't train our officers and allow biases to persist. So what are the ways that we do that? One of them is actually just having that written policy. And those who have Lexipol or CALIA, I think, have those model policies. If you don't, I know there are plenty of agencies that don't use either of those, but that do have good policies. It's important to have those in there to show that we don't permit any type of discrimination of any type, and that we will take corrective action where appropriate, whatever that is. The next thing that is really important is to have department trainings. And it doesn't have to be long. It doesn't have to be an entire session. It can be part of the daily briefings that can go out. Just remember this, or things that can help. I think one fairly detailed training of perhaps a 50-minute session each year is really helpful. That's what we do in the sexual harassment field. Generally, is to have that every 1 to 2 years. It's helpful. I know in our firm we put out a written policy and have the people sign that they've read that policy every year, and then also to have training on it to make sure, because as you're aware, the law changes, cases come down, and it's important to have those and to be up to speed. So trainings are good and can be very helpful. The next one that is a way that we can help fight and guard against these biases is to have reviews, the internal reviews that we do that can help officers recognize what they do in certain circumstances and how we can improve. And it's always very delicate to make sure that we word things appropriately so that there aren't any problems where it can be used as a sword, but it can be a very important shield for us as well. So if you ever have those reviews, I highly recommend that you consult with attorneys before actually putting things in writing. It's good to have those in writing, and it helps us, but to make sure that it isn't used as a sword against us, also to involve counsel in that, to make sure that the appropriate things are stated, but in the right way that doesn't do undue harm in the future. And then where necessary, it's really important to have corrective action. I know my mentor at my firm always taught me and taught the law enforcement agencies that we worked with that to do the right thing. I remember hearing him say that over and over. Do the right thing and we'll deal with the rest. And sometimes it requires taking corrective action. And that's important to do because we don't want to have a department where it can be said that we allow improper behavior to occur in any aspect, and that includes in bias cases. And again, those are very important to have counsel involved in now that you're taking corrective action, particularly not only to prevent against claims in the future, such as civil rights claims, but also to protect against claims by the employee who may assert a claim for that they were improperly and not proportionately disciplined. So, and it also helps create that record that the attorneys need to establish when things were consistent and proportionate, and sets that standard. Another thing that is really helpful that I have found when I have had civil rights claims with officers is when we have officers who have engaged with minority groups in their community. I had one case where an officer was alleged to have discriminated against someone based upon their race and ethnicity. And it was so delightful to hear this officer be able to say, I coach people of this very race and ethnicity on soccer teams every weekend, these 13 and 14-year-olds, and they'll come in and testify that I do that. So those things are so great. So not only, but more importantly than having those witnesses, it opens our perspective and it helps us to get those different perspectives and to listen and be a part of other people who see things and experience things differently than we do. So whether it's based on gender or race and ethnicity, sexual orientation, those types of things, to be exposed to people and to be involved in our communities, I think is really helpful. And that community-oriented policing really not only helps engender trust within the community, but helps our officers as well with perspectives. It applies to adults, to kids, and all community activities in which people can become involved. So I encourage you to encourage your officers to become involved and get to know those different types of perspectives. And there are just so many different ways and opportunities you have to do that, that it's not difficult to find. The next thing we want to talk about is making sure that you activate recording devices. So we have them now, right? And we have these people talk about body cameras daily. And the first question we get when we have an officer involved critical incident, particularly shooting, is what do they want? They want the body camera, right? Not all agencies have them. People expect them to. So if you don't have them, I would encourage you to have good written documentation as to why they don't have them. Because people in the public, judges and jurors all expect interactions with police officers to be recorded these days. We've had several cases where people do have body cameras, for example, or a dash camera, and they forget to activate the device until later. And it's been really hard because for two reasons. First is it doesn't capture all of the information that our officers, all of the good things that they're doing and saying. So whatever we can do to create a culture and a habit of having them, when they stop that car, push that button to start recording. And then one of the other problems we've had is that they've been turned off prematurely. Maybe the officer thinks that the encounter is done, and so he or she turns it off, or he or she turns it off to consult with other officers and then forgets to turn it back on. It's really crucial to make sure that those recordings stay on until the situation is over with. We just recently finished a case where officers did have their body cameras on, and it captured an interaction with the plaintiff that the plaintiff tried to say was much more extensive and violent than it was, and we were so fortunate to have it on the body recording. But what the officers did is they turned it off before they left the scene. They turned it off as they were walking away from the suspect's house with the person in handcuffs, and took the suspect to the car and didn't have the recording device on. And what the suspect then did was claim that the officers roughed the suspect up at that point, which wasn't caught on the camera, and it made it impossible for us to say that they didn't do it, and it can allow a fact dispute to be created because the suspect says one thing and the officers say another, and there's your fact dispute that prevents you from getting out on summary judgment right there. So make sure your officers understand the true importance of recording that until they clear the call and they are completely done with interacting with the suspect. And that if they do have to turn it off and consult with others, that they are mindful. One of the things that I do as I get older, I get a little more forgetful sometimes of things, and I have left my credit card at stores where I've handed it to the clerk when you used to have to do that and not swipe as much. And so what I'll do now is I have a wallet that I'll take my credit card out, and I keep my finger in that wallet in the place until the person hands the credit card back to me. And I won't move that finger away, so I make sure I don't walk away without that credit card. Something that they can do to remind them and keep them, knowing that they need to turn that back on. Maybe put their hand on their sleeve or something like that, so they consult, and as soon as they're done consulting, then that hand's still on the sleeve, and they take it and put it back on a button. Just simple things like that can help. And it's also important to notate in the report both the duration of the interaction and the recording, so that there can't be a claim later that it lasted any longer or that there was additional encounters beyond what was there. So if it's done right in the recording or in the report or right on the recording saying, I'm leaving now and not turning it off, but even better in the report after they are cleared from the scene, that gives another indicia that they are finished. So those are some helpful things, we think. One other that is really, that we're finding having some difficulty with officers is the tone. It's so important. I teach people when we get ready for depositions, sometimes it's not even what you say, but how you say it. And I actually try to teach my kids that too. First, do it because it's the right thing to do. You'll get better cooperation generally. Now, we all know that's not always the case. There are people who are just going to be difficult with law enforcement at times, and that they're not going to be respectful and difficult. But then the other thing comes along is that, remember, we're all walking around with those little computers in our pockets, and they have video cameras and still cameras right on them. And one of my dear friends who's a police expert and now a police chief now says, assume that you're being recorded. Don't ever wonder if you are. Just assume you are. And if you aren't doing it, someone else likely is. There have been many times where we have received, I'm sure you have, cell phone video that is booked into evidence that has been taken by others. So make sure, just assume you're always being recorded. In Utah, we're really lucky where juries generally look favorably on officers and are willing to extend the reasonable doubt to them. That actually is really helpful to us in a lot of circumstances, is a good shield for us, but again, it can be a real sword, because when they give us that trust and they feel like they have betrayed it, they really get upset. And they will punish officers for that. We recently finished a case in which there were some officers that were a little bit snitty with a suspect who was horrible to them. The suspect was sarcastic, was threatening them with lawsuits right at the scene, was confrontational, and the officers got caught up in it. And it's really hard. I'm guilty of it myself. I was in a deposition last week, and I got a little bit snitty back with opposing counsel. So I'm not immune from that, and I'm not saying that, I never make those mistakes. But we need to keep reminding ourselves that we've got to wear the white hat. And even when people are being difficult and disrespectful, we have to be calm, particularly where there are those recordings that's memorializing, because they will punish both the officers and the cities and counties and states when they feel like they're being heavy-handed. So it's always important for our officers to be very respectful in what they say, and not just what they say, but in their tone of voice, and to be calm. We don't want our officers ever to be sarcastic. We've had several things where they've, in words and phrases, where they've said things that are sarcastic. It's not the time to do that. They need to be not demeaning. They need to not act as though they're better or know more than our suspects. They need to be really try to be understanding where it's possible. Try to remember that police officers have a huge amount of authority, and people get afraid, and when they get afraid, they get frightened sometimes and do things they shouldn't. And sometimes they're just plain jerks and threatening. So, but still, we need to be the ones who wear that white hat and be polite, where it's so very difficult to do that. And where possible, to explain maybe what we're going to do next, where it wouldn't compromise officer safety, so that they don't feel surprised and threatened and worried about what we're going to do. Those are things that can really help in instances. Another one that we've had some experience in the last few years is we've had cases where officers have been authorized by statute to arrest someone, but it was for a minor offense, and we've had a couple of judges get pretty upset where they felt that the officers were being heavy-handed, even though the officers were completely justified by statute to arrest the person. We had a case that even went up to the 10th Circuit Court of Appeals, and they ruled against us about an officer that arrested someone for having a license plate lamp that was out, and took them to jail. Now, the officer was just going to give a citation, but the person became difficult and wouldn't give the officer the person was from out of state and wouldn't give an in-state address as required to do. And so the officer arrested the suspect for a license plate lamp violation. It really upset several of the case went through several federal court judges in the trial court level, at the district court level, even went up to the 10th Circuit, and a panel of 3 of the 10th Circuit unanimously and almost summarily was really upset with what the officers did. And when we asked the entire 10th Circuit to take a look at this, because we thought the appellate judges didn't get it right because the officer was justified in the arrest, they denied it summarily like a day later. They didn't even want to listen to it. They were so upset. So it's really important to remember to keep that balance. If someone won't necessarily sign a citation or give the information, but you have what you need, if they tear it up, that's their problem. Make sure that we're not, again, being heavy-handed and getting caught up on form over substance. The cases that I was just talking about have ended in settlements that were not insubstantial. They cost, quite a deal of money, and that was after having to pay attorney's fees to get through some of the discovery issues and file motions. So it'll save a lot of headache where people can ensure that they try to take the emotion out of a situation and remove oneself. And that's where other officers on scene can be very helpful too, if they just pull an officer aside and say, let's take a breather on this one, and provide a little perspective. Those can help a lot. The last we want to talk about is reports, which, as we hammer over and over and can't emphasize enough that they are so important. What I want to talk about here is we have had some cases, several, in the last little bit, where officers have made conclusions on traffic accidents or street accidents where they have said there was something wrong with the street or something wrong with the sidewalk. And the officer, at that point, there's no claim against the city and there's no thought by an officer that they can be sued. But what ends up happening is our city or our county or the state gets sued later for having a defective road condition or sidewalk condition, and the officer has put something in there, a conclusion that it was the entity's fault. And those can be used as a very powerful sword against us for establishing liability. So it's really important in those situations for our officers to make them aware that when they're writing their reports on these accidents or these road conditions, anything like that, to make sure that they're not rendering any opinions about whether something is at fault or the cause of or is dangerous, because those can be used later against us and have been. We want to make sure our officers keep the information factual. For example, if there's a ledge in a sidewalk, provide the depth of the ledge, an inch or 2, whatever it is, and just give that information and not say, I can see that was the cause of the accident, because we don't know. We have a case right now that we're dealing with where there was a substantial ledge in the sidewalk. In fact, it was so substantial that any person looking where they were going should see it. And that is a defense we have, is that it's open and obvious and anyone should be able to see it and avoid it, and they didn't. And the boy that was riding a scooter over the sidewalk and got tripped up on this ledge has vision problems, severe vision problems. And so it wasn't necessarily the ledge that was the cause, but the boy not watching what he was doing and wearing his corrective lenses to see this open and obvious thing. So make sure that we keep these to factual information and conclusions. And a lot of people, including most often, I will say attorneys, get confused about that. When I was working with a judge right out of law school, we were so frustrated that attorneys would couch as facts things that were conclusions. And if I can do anything to help train officers, what are facts and what are conclusions? Facts are really those identifiable empirical things, measurable data. This happened, it was this time of day, the who, what, when, where, those kinds of things. Maybe even sometimes the why. But how, the outcomes, when those facts get applied to the law, those are conclusions, and those are the things that we want to stay away from, and particularly opinions. And that's what we do, particularly in IA writing, we want to keep people away from opinions, but also in these police reports. Don't include any opinions. Keep it to the facts. So those are all of the mistakes that we have seen, and they don't just come from our jurisdiction. I hope you know that everyone out there is doing just a great job. And these are some pointers where we've seen plaintiffs take advantage, and we want to make sure that we try to minimize that and protect you all as best we can. If you have any questions and any specific information, want to challenge me about that, or need some case laws to back you up, like I said, please contact me at any time, or contact the trust and they can contact me, and we can provide you with whatever you need to help prevent things up front, so that when we do get into cases, we are best suited to defend as successfully as possible. Thanks for being here with me today, and appreciate all you do. Go out there, be safe, and God bless you for all you do.
Thank you, Heather. That was a great presentation. Folks, if you have any questions, you can type those into the chat box, the Q&A box right now, and we've got a couple of minutes that we could ask a couple of questions of Heather. I have one, if you wouldn't mind.
Absolutely.
Earlier, you talked about documenting when you're extending a stop, and you answered my question mostly. But what constitutes documentation? I think that's a good question for a lot of things beyond just extending a traffic stop. What constitutes documentation?
That's a really good question, Jason. So writing down in the report, what you did, when you did it, how long those things lasted, what the person said, and recordings can really help us in a lot of those aspects, and they can take that out. A lot of times when I'll meet with experts these days, I'll ask the expert if it's okay, or even witnesses, if it's okay if I record our conversation so that I can focus in on what they're saying instead of, writing those things down as I'm doing it. But after the fact, then I go back and I document that in some written notes that say specific things that summarize them well. And I'm doing my own sort of report, if you will, based on the conversation. So I keep that recording. But there are also things that recordings don't capture that can be helpful. So having a recording, supplementing it with a police report. Again, we've talked so many times about on recordings don't capture how the officer is feeling, or the subtlety of the lighting sometimes. You don't get those things. So documenting it means writing down those facts and things that support anything that makes you feel suspicious, or things that happened, how long things did. Write those down in the report and supplement those recordings. So recordings are one way, reports are another way. Witness statements, if there are witnesses, getting that from the witnesses, those are so crucial. I'm dealing with a case right now where I have a witness who completely contradicts and he's the only independent person in an accident that contradicts, other than my driver in the case, what the people in the plaintiff's car says. And it's so much more powerful to have that independent witness as opposed to people who are involved in it. So witness statements are another good way to document things.
Great. How about radio calls to dispatch or to other officers?
That's a really good way. Yeah, when you're calling in, you can include the information to dispatch. so that it appears on the CAT information, hopefully that gets put in. And if it's not on the CAT information, it's on the dispatch. You're right. Those dispatch recordings can be very important because it shows what officers know. We have a case right now where an officer didn't actually get to hear the 911 call, but the officer is relying on certain information provided by dispatch, and that's what the officer knows. And so to have those recordings from dispatch about what dispatch told the officer and what the officer said back to dispatch, that's a very good example of some documentation and how you can further provide information at the time so that people can't claim you're later fabricating it.
Yeah, for sure. Okay, we've got another question here. Are the courts, judges, juries somewhat, quote unquote, understanding of the fact that body cameras and other technology isn't perfect? Batteries die, buttons get pushed wrong, angle is knocked off, et cetera, et cetera.
Yes, I think they are. But what we want to do is we want to make sure that when we have those, so what I went several years ago and became Force Science certified because I wanted to understand as best as I could some of these issues. And I remember speaking with Bill Lewinsky about that very thing. And Bill said, he said, there are certain angles that can maybe be misleading or the time. But Bill said this, I would always rather have a recording that I can work with and I can explain what is happening rather than just not having anything at all. And I tried a case several years ago where we did have a recording that didn't capture certain things because an officer was standing between the dash camera and the person. And we called in someone from the recording, the camera company, to testify about why there was a delay in the recording coming on and certain angles and how these things appeared. And the jury was very interested in that, and they listened, and we ended up getting a no cause of action on that, where the recording actually looked pretty bad itself. So I do think they are understanding. They just need to be given a really reasonable basis for why something may have gone wrong in the recording and how and why it may not show certain things, but the officer wrote them down in the report.
Awesome. Thank you so much, Heather. What a great, we had another question. I was just about to wrap up. Do you think one or two dimensional evidence is carrying greater weight than an officer's eyewitness testimony?
No, I think the most important thing is the officer's testimony, and here's why. People believe people. They want to trust someone, and so when I work with my officers, I always try to tell them your demeanor is the most important thing, and if they don't trust you and they don't believe you, then it doesn't matter as much what a recording shows. And as I gave some examples on here today, there were instances where officers did things appropriately, but the tone was really bad, or they came across as heavy-handed in what they were doing, and they got punished for it. So I think it's always, the human component is absolutely the most important part to anything. The recordings are there to supplement and protect the officers, and I think they do. But absolutely number one is the officer being the trusted guardian and caretaker of the community.
Great. Thanks, Chief Burton, for those questions. Those were really good. Really appreciate all of you attending today, and really appreciate Heather for coming in and giving this great information. I know some of these things may be a reminder, but I think this is just so important day to day. We get very comfortable doing the things that we do. I think this would be a great reminder to all of our officers out there of just the subtle nuances that can make a big difference. Any final words, Heather?
No, just appreciate all you do. I know it's a busy time of year with summer getting going and late nights and lots of gatherings. So good luck and stay safe.
Awesome. Thanks so much, Heather. Everybody have a safe day out there.